Yeah.
Yeah. Well,
And Hendrix got somebody too. Who does Hendrix have?
Mr. Lee? See that. He's not here?
No, he's here.
All right. Well, okay. We're waiting on the report?
Yes.
Okay. All right. Well, that's him. Yes, yeah. That's him. Yeah, he's back. Yeah. So good. What is he doing? Probation.
Went down this time at the Grand Hotel. Steps that were not level. You know, I'm not in the right foot again.
That's what does. It's not fast for you to have a key. Yes.
Well, knocked out teeth and not neither. But I caught myself, which was worse. He's signed.
Yeah. Be right with that much short.
Here. Does somebody need to perhaps you need to begin this to sign and stamp the copy? And is nothing ready?
Is there Joshua Bullock in the court?
Up here says not.
That's a very little period.
Bullock. Okay. Let's do Bullock then. This is case number M4520469 A and B, people of the state of Michigan versus Joshua Bullock.
Robert Shockley on behalf of the people.
All right, Mr. Bullock apparently was scheduled this morning for a pretrial operating with no license or multiple licenses. And there's an accompanying civil infraction of no proof insurance that's already in default for $150. This matter was scheduled for 9 o'clock. It's 9:50. Looks like 9:54. So court will issue a bench warrant for his arrest. Forfeit any bond. And let's see, the new bond in this matter will be $600 cash or surety. And of course, in this matter, the default will remain. This is case number 25S00823SF, People State of Michigan versus Quincy Wells.
Robert Shockley on behalf of the people.
Oh, you saw on behalf of,
Sue Wells.
All right, Mr. Wells, you're here for a pretrial on one count of domestic violence. Maximum penalty there is up to 93 days in jail with up to $500 fine. And then you also have a second count, which is a malicious destruction of personal property. less than $200 in a domestic relationship, that's a 93-day misdemeanor. There's also a $500 fine or 3 times the amount of the property involved or allegedly destroyed, whichever is greater. So you understand the two charges? And you do have a right to have a trial by judge or by jury with Mr. Starr representing you. And you understand that? Right, this is our first pre-trial, Mr. Starr. Do you have your discovery? And if so, how would you like to proceed?
Nah.
Okay. Is there just paper or is there more?
This paper and video, which it appears I do have the video in my possession, so that will be sent over.
All right, we need an adjourned date for discovery.
Available September 8th at 9 a.m.
How about that?
I got a jury trial. Where's September 9th by 8?
8th.
Yeah.
Okay, September 8th at 9. Fine is continued. This is case number 25S00732 SM, State of Michigan versus Roderick Pope.
Robert Chuck, on behalf of the people of Your Honor, Attorney Baldwin is over in Judge Baines.
Is Mr. Pope with you? No.
Outside talking to.
Oh. All right, one. This ain't ready. What's ready? This? Case number 23S00438 SM, State of Michigan versus William Lee.
Robert Chuck, on behalf of the people.
Hendricks Morris on behalf of William Lee, please state your record, sir.
Okay, Mr. Lee, we're here today for a probation violation matter. You're on probation to the court for aggravated domestic violence. Maximum penalty could be up to 1 year. Looks like we took a plea previously and had adjourned your sentencing. You were going to, at last time we we're here, obtain proof of completion of the HEAL program, pay on your fines and costs, and continue your drug screens. The allegations that you pled to were haven't paid fines, didn't complete HEAL, didn't do screens, and didn't complete anger management. So let's see.
Well, Your Honor, we're kind of in the same position we were in the last hearing, and I forget the adjournment.
August 13th.
Okay, the 13. Mr. Lee she's showing me the text messages he's sending to Mr. Kate to get his deal verified.
You know what? That's Miss Kate, even though the first name
Miss Kate.
is Jeffrey, it sounds like a man, but
Yeah, that's right.
yeah.
Miss Kate, going back and forth with Mr. Lee and like can't get this verified for some reason. I don't know what the problem is.
Well, do we need to have her come in for sentence?
Maybe so, if I'm not sure, but
I don't know what did the text messages say? What's the problem?
you're sending yours.
She says. And I think their last. Because she's not.
She's not doing classes.
Yes, she's on vacation.
Okay. Mr. Shockley. I'm going to adjourn this one time. Could you make sure I have someone from the HEAL program who will be here to verify whatever his status is? If it's not, it should be Miss Kate, but if it's not her, whoever else is in charge over there.
What's the name of the business sign judge?
This is Mr. William Lee, and apparently we've been having trouble.
You said Miss Kate.
Jeffrey, Kate, CAPE. We've been having trouble getting verification from her, and he just said she's on vacation or not at work or something, and
Didn't you say she's on the road?
Yeah, she said she was on the road.
she was on the road. She's back today. We're just gonna need to get her here. Because I'm trying to understand what's going on here. So what about the money? Did you pay him the money?
I can pay him each. So I paid 600. I'll be able to pay that 600.
Okay. Gonna write that down. You're gonna pay $600 on August the 29th. Got the prosecutor getting Miss Kate to confirm his status and what's going on with the drug screen.
On probation.
And they have a note here as of August 22nd. Kate indicated he has not completed healing. I don't know what that means.
Didn't know that same day. She probably said, I'm pretty sure that same day.
That's okay. I'm gonna adjourn it one more time. What's the new date?
How long does?
Mr. Shockley is the only one. Depends on what he can do. When do you think you can get her available? How much time?
I'm sorry,
We need a date for this, and I'm asking when do you think you would get Miss Kate or someone?
I mean, honestly, I've never subpoenaed anyone for the HEAL program, so I mean, 2 weeks,
Okay, 2 weeks.
that's sufficient notice.
Court's available September 8th at 9:30.
Okay, I'm already in the Bible training that morning, so.
Okay, good. 9, 8, 9:30. And this will be for the sentencing on the violation of probation. Case number 25S00016 SM, State of Michigan versus Michael Ed.
Chuck, on behalf of the people.
Morning, Brother, you've got some moments there with behalf of Michael Head, who's a coach. Please take your name to the record.
Michael.
All right, Mr. Head, we're here for trial today on what kind of domestic violence. People prepared to pursue.
Yeah, Honor, as the court remembers, the victim, the complainant witness, Samantha, did testify. At the time, based on the testimony of the witness, the people would move to amend the charges to one count of assault and battery rather than domestic violence in 93-day misdemeanor.
Okay, so we already had Opaline Johnson. Oh, I don't have my notes with me. All right, so you want a minute to assault and battery? And now,
Lesser included.
okay, now what?
People rest at this time.
Your Honor, at this time, the defense will call my client as on stand.
Okay, could somebody give me the notes on this? You know, it was a trial that we were actually gonna hear it the second. Okay. Okay. All righty. So people have rested. Let me make a note of that. All right, and you're calling who, Ms. Westmoreland?
Your Honor, my client would like to take the stand.
Oh, okay. Sir, you want to testify? You need to come on over here. Right, and raise your right hand. You solemnly swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth.
Yes.
All right, thank you. Have a seat. Try to keep your voice up so we can hear you through your mask.
Good morning, Mr. Head. Can you please state your full name for the record?
Michael Hay,
And can you spell your last name?
Head.
You don't have your mask on.
Yeah, I know.
Just telling you.
No, I'm that because I have a cold.
Do you want, would it be, it might be easier if you can maybe take it off, because you're not near you're sitting near anyone, and it'd be easier for the court reporter to read.
Particles do fly through the air. I don't want to catch what he got.
Okay.
Leave it on.
Good.
Okay.
Just speak loud.
Yeah, that's fine.
All right. Mr. Head, I'm gonna, can you please take us back to January 3rd of 2025?
Yes, okay,
Where were you living at that time?
at 27600 Franklin Road, Park 203.
And who did you live with?
My stepdad. Louis
Okay,
Jackson.
I'm sorry?
Louis Jackson.
Thank you. And how long did you live with Mr. Jackson?
Say almost 2 years.
Okay. Did anyone else live with you two?
No,
Just the two of you?
yes,
Okay. And, we were present here a few weeks ago for the first part of your trial. Do you remember that day?
yes,
Do you remember, hearing testimony from an Opaline plumber?
Yeah.
Do you know an Opaline plumber?
I got Johnson.
I believe she said she changed her name. Your Honor, the police report has plumber on it, and she indicated that one was a maiden name and one was a married name.
Okay. All right.
How do you know Miss Plummer / Johnson?
I know her because she's my dad's, friend, one of his friends.
Okay. Did you see her on January 3rd?
Yes, I did.
And when did you first see her on January 3rd?
Well, first, my dad called me and asked me to pick her up. Then she called me and asked me to pick her up. So then I went and picked her up, take her to the apartment.
Around what time did you pick her up?
It was around 10 o'clock at night.
On January 3rd?
Yes.
And where did you pick her up from?
It was on out of driving, Point. Out of driving Point's apartment. One of her other friends stayed there. I was picking her up from there
And where were you taking her?
to my dad's apartment in Scottsdale, 27,600.
Okay. And both of them asked you to pick her up and take her there?
Yes.
Okay. And, do you know why she was coming over to your apartment?
Yes,
Objection, speculation. Foundation.
I know why they was coming in.
All right, well, tell us why. Why do you know?
Cause I do it all the time, but I'm just their driver.
Okay.
I pick his friends up, and bring them over there and take them back. They come over there, play cards, and get home. That's what they do.
Okay, and, so when you dropped her off that night, what did you see them do?
Well, when I dropped off, it was Larry, another girl there, and then it was her and my dad. They was already playing cards, drinking, and smoking crack. Then my girlfriend called, so I left to go to my girlfriend. Then around,
Wait a minute. So when you dropped her off, they were already there drinking?
yeah, my dad, Larry, and I don't know the other girl's name. And so I went back to my girlfriend, knowing I had to come back, take Larry home, because he had to go to Dallas in the morning around 5 or 6.
Okay, so just to clarify, when you dropped Opaline off at the apartment, your dad was there and he had two friends over already?
Yes.
Okay. And when you picked Opaline up, what was her demeanor like?
Well, she was already happy, because that's what they do over to the other guy's house.
Objection.
What's the objection?
I know because
Okay, sir, hold on.
Hold
There's
on,
an
let me
objection.
finish.
So I still don't have a foundation as to how he would know that she.
Okay, you wanna go? How do you know that she was high? How do you, okay, excuse me. How do you know she was high? Have you seen her high?
Yeah,
And how does she act versus have you seen her not high?
yeah, yeah.
And what was the difference today that made you think she was high on that
I
day?
took him, the guy's apartment she was at I took him to go get the stuff. Earlier, checked it.
Okay, how do you know she though used it?
Cause
How
her
do you know
mouth was twitching,
her mouth was twitching?
shaking, you know.
And is it normally do that?
No. And then she smelled like liquor.
And that's only when she what? Does it twitch?
She twitched when she smoked crack.
Okay. Yes, that's how he knows. Go ahead.
All right, have you taken Opaline to your dad's apartment before?
Yes,
And, in previous occasions, how long did she hang out with your dad for?
they can hang out for days. Sometimes, see, they'll start like on the 26th or the 27th. And they'll stop around the 3rd or the 4th. That's because they all get them first of the month checks and stuff. And they like to go there because it's safe, because they don't have to go places. They can sit right there. And I take them to go get stuff and do stuff. That way they don't have to be around a lot of people.
Okay, so you, in previous occasions, when Opaline would come over, they'd hang out for days, you said?
Yes,
And for days, would they play cards?
yes, play cards.
What else would they do for days?
I don't know all they do because I don't be there all the time. I just be in and out, because if the other people I have to pick up and take places like the markets, stuff like that. I'm just there dry.
Okay,
And then I like it that way because it keeps my day 88. I don't like him to be out in the streets getting high. That way he can stay at home, not have some kind of control over.
okay. So you indicated after you dropped Opaline off, you left to go to your girlfriend's. And then, did you come back at any point to the apartment? When did you come back?
Came back about 1 o'clock
Okay, and
1 o'clock AM?
in the morning.
Okay.
so that would be the following day on January 4th?
Yeah,
Okay, and when you came back, what were the three individuals doing?
it was all in the living room, playing cards, drinking and stuff.
And what did you do when you got back at one
I
AM?
asked the man what time did he want me to take him home so he could go to the house. He said, give him a little bit of time. He said, give him a few minutes, I'll take him. So then I went to my bedroom and just to lay down for a minute. She knocked on the door actually for a lighter, so I ain't got no lighter, I ain't got no.
Okay,
Hey, my
hold
dad.
on, let's slow down a little bit, okay, because we need to know who she is.
Opal.
Okay, so you said you came back to the apartment around 1.
Yeah.
And then you, eventually went to your bedroom and you lay down. And then later, Opaline knocked on the door, you said?
Yeah.
And asked me for a lighter. You didn't have a lighter,
Yes, I do.
but did you give her the lighter?
No,
Okay. And what happened next?
then my dad came back and forth. So I got a little upset that they keep bugging me for stuff that I have and they just do what they do. So gave him the lighter and I left. I just left to go sit in the car, but my brother stayed like 2 lights from this, so I went in to his house. I
So,
knew I had to pick Larry up, and take him home.
okay, so you gave your dad the lighter and you left.
Now,
Okay, and you went to go to your brother's house? Okay, and, at any point during your interaction with Opaline, did you hit her?
No,
Did you choke her?
no,
Did you at any point touch her?
no.
Okay. Did you come back to the apartment again after that?
Yes, I did.
When did you come back again?
It was about 5, something like that. 5, around 5.
And why did you come back?
Because I had to take Larry home.
Okay,
I mean, yeah, I had to take Larry home so he can meet people up for down.
dialysis, is that what you said?
Yes.
Okay. So when you came back, did you see your dad?
Yeah.
Did you see this but you said there was a guy named Larry at the apartment?
Yeah, Larry,
And was Opaline still there?
she was there and there was another guy.
Okay, another
I mean,
guy,
another girl.
another girl, okay. And what were they doing when you got back around 5 a.m.?
Same thing.
Okay. And then did you take Larry to his house?
Yes, I did.
Did you have any interaction with Opaline during that time?
I didn't. She wanted me to take her home, but I told her I didn't have time. I had to pick her up later on, but after I dropped him off, I was going to go back to my program, so I could give you some rest.
Okay, so, did you, at any point around that 5 a.m. window that you were at the apartment, touch Opaline?
No,
Did you hit her?
no,
Did you choke her?
no,
Did she attack you?
no.
Was there any physical contact between the two of you? Okay. All right. And were you ever in a relationship with Opaline?
No.
Okay. No further questions.
Your cross-examination.
Yes, Your Honor. So I'm going to ask you a series of yes or no questions. If my question calls for anything but from yes or no, obviously I want you to explain further. If you don't understand my question, please tell me, Mr. Shopping, I don't understand what you're asking me. If you don't know, you don't know. Okay. So, it's your testimony that on January 3rd went to, I believe you said out of drive to pick up Ms. Plummer? Yes. How long have you known them?
Maybe about,
You have your own friendship with her? No.
you know. I mean, I see her, you know, by picking her up, something like that. I mean, we don't focus.
You testified previous to coming to pick her up, you drove someplace to pick up crack cocaine for another individual, is that correct?
Yes, when I picked her up, I did that for him earlier that day.
Were you, have you ever used crack cocaine?
Yes, I have, back in the 90s.
Back in the night. So you haven't used it recently? You didn't. It's your testimony today that you did not use it today,
No, I,
or on the date of this incident?
no, I don't.
Fair to say you don't know exactly what went on in the department between 1 and 5 o'clock, because you weren't there? Um. Then you heard Ms. Plummer testify to what she witnessed that day.
Yes.
And you testified that you weren't using crack cocaine, were you using any other drugs that day?
No, I drink.
You drank,
Beer.
were you drinking beer that day?
Yes, I,
How many beers did you say you had? One,
during the course of the day,
two?
during the course of that day, I have a 6-pack,
Okay. When did you start drinking it?
room,
But, yeah, okay. So it's your testimony today that Ms. Plummer never even came into your bedroom?
came to the door, came in the doorway of it. I mean, she didn't come and sit down on the, none of that, she came and asked me.
She was never on your bed.
No.
She was, hey, you never put your hand.
No.
You never got upset at her that night?
Yes, I'm saying it all the time. He always asked me for stuff. I don't touch him or none of that. When you get upset, if somebody asks you for a lot of 30 or 40 times a day. Oh, man.
After this incident, it's your testimony that you left the house and then came back around 5.
Yeah.
What did you go do between 1 and 5?
Sit in the person, driving my brother's house. Then he hollered out to me, told me to come on in, so I went in the house.
You also said the name Larry. Who's Larry?
That's one of my dad's friends.
Have you known Larry for a long time?
Known him for about 2 years. He's about 80-something years old people. And they have a bunch of young girls.
So,
Wait a minute. I can't. They got a lot of young girlfriends.
Yeah, they do. When they get them checks, they'll just come by around that shit.
It is what it is. It's shocking.
I have no.
Good. You got anything else for us? Okay, thank you, sir. You may step down. Do you have another witness?
No, Your Honor.
Good. Okay. Defense is resting. Any rebuttal, Mr. Johnson? Okay. All right. Well, we're at the conclusion with the two witnesses that we've heard from. You ready to do a closing?
Yes, Sean.
Okay, go ahead.
Previous to the state, you heard the testimony. Hopefully Plummer, also known as hopefully Johnson. She testified on January 4th, 2025. On that night at 27600 Franklin Road, apartment 201, city of Southfield. The defendant became angry at her. She testified that the argument was over this lighter, which the defendant himself has confirmed that she did go to his room and ask for a lighter. Now, that's what the story is diverged. Ms. Plummer testified that at that point.
So when we say Fuller,
Plummer.
what's when she testified, she said her name was Johnson. So I'm kind of, what is the other name?
Plummer.
Plumber. Okay, go ahead.
When Ms. Johnson testified, she testified that she was under the defendant's best. That at that point in time, the defendant became very angry at her and then pulled her off that bed. During the course of pulling off that bed, he put his hands around her neck. She was pulled from the bed and she got out of there. This has to be around 5 p.m. As that's when the defendant came back. So the defendant testified. The only thing different between what the defendant said and what the victim said is that this assaultive event did not happen. We know she was there. We know it was at this apartment. We confirm around what time this occurred at. The only cross-examination that I really heard from sister counsel is about a drug use. And it's my position that I believe she was trying to use suppressed drug use to diminish her credibility. Here's the thing, Your Honor, and this is why I'm going to ask the court to believe her. At no time did it come out that there was a motive to lie. At no time did she try to diminish her drug use. If someone's going to lie about something, they're going to lie about something that's embarrassing. If someone's going to lie about something, they're going to do it in this public forum because it's embarrassing. She was completely honest, open, and honest about her experiences and her addiction issues. Did not try to hide from it. She's not try to run from it. I have no reason to disbelieve that on January 4th, 2025, that the defendant and Ms. Johnson were in his bedroom. The defendant pulled her off the bed, placed his hands around her neck, and strangled her for a brief period. Now, as the people just did before we came to this point, changed the charge to assault and battery rather than domestic violence because Ms. Johnson testified that they were not in a dating relationship. They've never been besides for, she alluded to one time an instance of sexual intercourse which she did not consent to.
My note says she never dated him. They had a relationship because he forced himself on her, whatever that meant at one time. That's what she said.
That, Your Honor, people actually found the defendant guilty beyond a reasonable doubt of assault and battery. Thank you.
Your Honor, Ms. Johnson's testimony was, I would say, all over the place. She did not know what time or what date she came to, the apartment. He first testified, I believe it was around 5 or 6 PM, then it was at noon. She was all over the place about the timing. She also testified to the fact that she was awake for days by that point, high on crack cocaine. She further testified that she did not know how the alleged assault happened. When asked to describe the events and to talk about how the assault happened, she couldn't remember and she couldn't provide any details. She just said it happened. Your Honor, I don't believe her testimony was credible for the lack of memory that she had regarding that particular day or that weekend, I would say, that period of time should tell the court that something wasn't right with her testimony, that there's some issues with the truth of what she testified to. My client testified today, was clear in his answers, discussed the exact timeline of when he picked up Miss Johnson, when he brought her to his dad's apartment, when he came back a couple of times, when he left. There was no indication during his testimony that my client was untruthful. I do believe that there is reasonable doubt in this case, that the prosecution has not met their burden of proving beyond a reasonable doubt that my client committed assault and battery on Miss Johnson. And I ask the court to find him not guilty.
Okay. Anything else, Mr. Shannon? Okay. I am going to take this under advisement for a minute. Go back, refresh my memory. I'll come back with a verdict. But I can do some other things before we get there. So, is that this one?
Yeah.
Yes. Mhm. Mm.
Oh, sorry. Let me add that. Okay.
Okay, thanks.
Your Honor, are you looking at Mr. Madison?
Wade. All right, so this is case number 25S00454 SD, People of the State of Michigan versus Terrence Wade.
Robert Shockley, on behalf of the people.
Good morning, Your Honor. These Nestamo, I'm here on behalf of Terrence Wade, standing to my right. State your name.
Okay, Mr. Wade, you're here for sentencing. This is on one count of operating while intoxicated. This is your second offense. There's a pre-sentence report. There's also a bad notification of a missed sober link test on August the 13th, too, and a full pre-sentence report. So anything you wish to correct on the report?
The only thing I wanted to correct or update the board regarding his employment, it says he's a construction worker
Yes.
and it's a waste management.
Oh, so we have to cross off that, cross out construction.
Sorry, Your Honor.
I'm a former for Barbados construction.
A
Oh,
foreman, but that is
okay,
construction.
that is, I'm sorry, I have my notes. Sorry, I have it. Right, never mind. He had prior experience from waste management.
Okay, so that's good.
Other than that, Your Honor, there's no additions, deletions, or corrections to the report, just allocution when the court is ready.
Okay, and why did he miss this test?
Your Honor, if you did fall asleep, the pretrial services report does indicate he blew at 10:44 PM and it was negative. He's late.
Okay. That's not good, because late means you missed it.
And I also want to note on the report, it does say that Mr. Wade has excellent record of compliance past. He actually received a text message from his case manager a few days ago. If I may read it into the record, Your Honor.
Great.
Mr. Wade, this is Linda Barnup in pretrial supervision. I just want to say you've done excellent on your SoberLink device, and I am proud of you. It is very difficult to have such a good track record on this device. I wish you the best of luck at your sentencing next week.
Okay.
So, he's been tested 5 times a day, Your Honor. I know he was late, but he did make it up 44 minutes later and it was negative. Your Honor, as the court, I don't know, if Mr. Shockley has anything regarding the PSI report? Right. Okay. As the court recalls, we tried to get Mr. Wade into sobriety court with Bradford District Court, and he was accepted, but unfortunately due to procedures there and this court's protocol, he is unable to be transferred to 17th District Court, but he had every intention and he really wanted to do sobriety court. He did their assessment, he did fee. He's been on bond since May, Your Honor, testing on the SoberLink device. I'm asking the court to take that into consideration when sentencing him in this manner. I'm requesting the court to consider an 18-month probation term rather than the 24 months recommended. And I believe he's got 1 day jail credit. I know there's a 5-day requirement for an OWI second. The only thing we would request for if the court was to impose the remaining 4 days of jail, we're asking the court that he be allowed to turn himself in tomorrow by 5 PM.
That's not a jail sentence.
Okay.
It's 3 days in the impact weekend and 8 days in the work
If the court
program.
was, and we'd be happy if the court gave him that, but I was just saying, if the court was going to give him.
I'm not gonna do it.
Okay, I appreciate that, Your Honor. Thank you. There's nothing further, Your Honor. Thank you.
What do you wish to say? This is your second time doing this. So you got to step back out of yourself and look at what's going on with you, like you're not you. And figure it out. Like you see a guy that's drinking for what? And to get too drunk driving. Because most people can't say they've had one.
So,
Yeah.
it was like, I stopped drinking and everything. I drank occasionally for his birthday. I was selling her, she had big work, I lost 52 pounds.
Good for you. And drinking stopped and you lost the weight. Oh, is that from your fall?
It's my son. It's fine, it's fine, and so,
Okay.
um.
So what's that got to do with the drinking?
I just had a drink with my brother. They left.
Okay. How does it get to a point that it's over the legal limit and you're driving?
What I think he's trying to say is that due to the accident that he suffered, it led him to making the bad decisions, I guess.
Is that what you're trying to say? How'd the accident cause you to do?
I didn't go out from there.
So then when you did go out to celebrate, you just drank, you should have had the opposite effect. Because if you don't drink, one little thing should affect you and you say, oh, that's it.
I'm gonna escalate. 21 escalating. Somebody dropped, so I just went around. Then jump back in front of them. Next thing you know, I got stopped. That was the everything I'm taking accountability for.
Okay. Let it happen again. A third time will likely be a felony. I mean, it's not worth it, is it? And if you're gonna go to the birthday party and you're gonna drink whatever you drink, why you driving? You could have just gone over there with somebody or Ubered there and back.
Right. This so very, yeah.
I saw that. So that caused you to drink a little bit more?
That's why I just want her to understand what I'm going through. Those one with the same mistake.
You brought your daughter where? Okay. Yeah, that's she. Well, good for you. Because that's what an accountable parent does. It shows their young people that they're not perfect. They do make mistakes. They are held accountable. And so should she, if she made any judgment errors of any kind, and not to be drinking. But drinking is easy for young people to fall into at college. And the next thing you know, they're at a party, it's been raided, folks are getting arrested, folks are illegal underage drinking. Or if that doesn't happen, somebody's drunk, and the next thing you know, somebody has said they've been raped. So nothing good could come out of excess drinking, especially on a college campus. But not even here, not even at your brother's little celebration. Just look what happened. So it's a good thing that you brought her so that she could see the process. She still respects you because, you know, you're accountable for this. And that's a good lesson to teach her and to sit down and talk about it. I like that. But the bottom line is your sobriety is everything. It can ruin your job. It can ruin your future. It can lead to another one of these, which could put you in a situation where you're not before a district court judge, you're before a circuit court judge, talking about, 1 to 5 years in prison. That's not where you want to be. And that technically ruins y'all. You think the divorce is hard? Yeah. Hard labor at Jackson. It's hard. And that's just no kind of drinking, no kind of nothing is worth all that. So you have to constantly think now, I can't do this anymore. The next time you see a bottle of alcohol calling your name, you have to look at it and say no. Well, you better assess the totality of the circumstances as to why you're drinking and where you are and how you're going to get home. And this is after you offer this probation. Because it matters. And people forget, oh, I'm just here this one time. No, don't forget, this is your second time. And the third time is not a charm, it's a felony. And you can't let it get there. That's everything you worked so hard for in the last, whatever, you're only 45. So let's just say you've been working since you were 20. So the last, 25 years. All right, everything will be gone. So, you have to think about it. So Anyway, it says here, you normally consume 2 shots of liquor. Why shots? Let's talk about that.
Right. I just think occasionally, some shots.
Okay, well, why a shot?
Well, it's-
That's not a shot. A shot is just pure alcohol. And why would you drink one? The whole purpose of that is to feel the effect of it. To get drunk or to get buzzed, which is drunk under the law, basically. So what's the point of drinking a shot? I mean, you got to know a shot is going to get you high. And where's the legal limit? You have no clue where that shot is going to take you on that scale, let alone 2 of them. And obviously, for you, it took you to 0.10. There you go. So if you're drinking and drinking, the whole point is to get high. Stop doing that. You know, this wasn't like, you had a little lightweight drink and it was mixed with some Coke, lots of Coke and lots of whatever they mix drinks with. This was a shot. There's nowhere it could take you but drunk. So if you got to think about that, I'm going to get drunk if I drink a shot. I might not get sloppy dead drunk, but it's going to affect me to the point that it could be enough to get me arrested if the police stop. Because driving a car is good. You might be good at that. And it's still illegal to be over that 0.10 or 0.08 now. The 0.08 is low. And you don't know where you are on that scale. So the idea is don't be doing stuff that could possibly get you there. And drive. It's not illegal to drink and drive, but how do you know where you're on the scale? So, in any event, so that's how you got caught. You were driving a little fast and passed the car. And it says here the needs assessment came out to having a mild alcohol use disorder without a specific drug of choice. Level 0 suggests more investigation is needed. And they're recommending outpatient substance abuse counseling. I don't disagree. I'm sad that we couldn't work out the sobriety court for you. Potentially, it might have worked and helped in many ways. But this court is willing to sentence you and to try to, put some things in place to help you become more aware. And hopefully you don't lose your awareness when you're done with this. Mr. Shockley, you said you didn't really have anything you wanted to add to this, or did you?
Did not, Your Honor.
Okay. Sentence of the court, 24 months probation. The oversight fee is $960. Now, if in fact you have completed everything after 12 months, you can ask the court for an early release from the probation. So that means we have a form that you can ask probation for. You fill it out saying why you wish an early release, what you've accomplished, how you benefited. Probation will then update it and indicate what your level of compliance has been. They'll send it to the prosecutor. If he doesn't object, they'll send it to me. And if I don't see a problem, I'll just release you on paper without a hearing. If I do see a problem or if the prosecutor objects because they have an issue, then we'll have a hearing and make a determination if this is what we need to do is release you early. So you can be released, but everything has to be complete except for payment of fines, because we could always put you on a payment plan if you have not yet completed all the fines after 1 year. But everything else has to be done. Okay? All right. So right now, the fines and costs in here are $800. Jail term is an alternative, 12 days, credit for 1, 3 days in the impact educational weekend. The other 8 days are in the Southfield work program. So if you do those programs, there's no direct jail. Then you also give me 3 days community service at a nonprofit agency. Attend the victim impact program. There will be the outpatient substance abuse counseling. Of course, no alcohol or prescribed drugs. They'll be testing for that. I'm gonna do AA meetings 4 times a week. It could be online, or you could go, or a combination of the two. No driving without a valid license. Do not frequent places where alcohol served or sold, primarily, such as bars, nightclubs, parties, and certainly not at home. Maintain your employment. There is a $75 crime victims' rights fee, $100 substance abuse assessment fee, $200 counsel fee, and the cost of reimbursement for the blood draw, arrest, prosecution, $600. And that, I believe, is going to complete the sentence in court. And you'll go down and check in with probation, and they'll tell you what they need you to do to get this all started. If you're enjoying the use of the device you've already got, then you could keep that if you want, or you want to just go to testing. Okay, so we'll remove. Sober link.
Sorry.
Okay, I'm gonna put something else on here, so. Okay, so that's gonna complete the sentence of the court now. We're all set. He has a $200 bond though. Let's see, Charles Wade posted that. Oh yeah, Charlicia. Yeah, sorry. Who's that, your mother? Oh, your wife, okay. Okay, well, does she want the money back? Probably, doesn't she? Okay. All right, she has to sign it over because she put it in her name. Well, then, she should do the right thing and sign it over so it can be applied. So I'll just make a note, but you got to tell her she's got to do that. Yeah. Mm-hmm.
In custody.
Okay, he's going to take it down. You're all set. Good luck. All right, this is case number 25M00214SD. People's State of Michigan versus Renee Douglas.
From Sharp on behalf of the people.
On Ron Trojan Star at Douglas. Douglas Station.
They need Douglas.
All right, Mr. Douglas, we're here apparently for a sentencing. Mr. Starr, you just on this now?
I've been on it, but for some reason the appearance was not sent on. I was here last time. And this is separate.
Okay, no sure.
This was originally separate sentencing. August 4th.
Oh, what happened then? Because he didn't show up for the report.
That was back in April. Mr. Douglas has been in custody open time since July 16th. Okay, but they didn't bring him over since August 4th.
You've been there since July what?
16th.
Okay.
Probation, what they told me is that they were not informed that he was not in custody. So they didn't do, they haven't talked to him to do a PSI.
Right.
They want us to come back for a third time. Your Honor, I'm asking, this is OWI first,
that he pled guilty to.
Well, why can't, how can I sentence him with no report?
Well, I believe you can.
Nope. Got to have a pre-sentence report.
So it's not possible to just sit simply.
In my understanding, no. I think by statute, I think I have to get a PSI. Now, we could try to do it quickly, since now we know he's in custody. So, Jessica, give me a date.
Court's available September 3rd at 9 a.m.
All right, he does have a pending, felony
When is that?
hearing.
When? So what?
So they tell me.
September something.
He's
Can they do the PSI the same day?
That's what, yes, Judge. They're gonna come up and, do it the same day.
Except for a pretrial before Judge Anderson on September 18th at 8:30 a.m.
Okay, so September 18th. We're coming back here, September what?
3rd, Judge, 9 a.m.
Okay, September 3rd at 9. Is that for sentencing or is he gonna be interviewed at 9?
They're gonna come up and interview him and then sentence him. They sentence him later that morning.
So why are we saying 9? Just for,
I have 11 a.m. Hearing. So trying to get this done quickly.
yo, they'll come up. The problem is, I don't know when they're gonna have the report done. And you need to go to Romulus. You need to leave by what, 10? 30? 10?
Different date.
Hmm?
Different date.
Yeah.
Get it done as quickly as possible.
But that is quick. That's like a week. And we can't do any quicker than that.
Court's available September 5th at 9:30.
Yeah, that works.
Okay, that's better for council, September the 5th at 9:30 a.m. And then, sir, you'll be here and they'll come up and interview you and have the full report done for you and council to go over before sentencing.
Mr. Douglas wants to know. He's in custody.
No, we got to interview him. He's got to fill out some paperwork. He's got to take an alcohol assessment test. We can't do that on Zoom. You got to be here.
All the way there. Get back and forth here.
Sir,
Wow.
I don't know. Listen, I need to get this report. I don't know if you might do time. I don't know, but I got to have a report so I can make an informed decision on this, period. And in order to get the report, I have to have your body. Then we go from there. And your lawyer can make the argument that he wants about you just want jail or whatever. But I just have to have the report first. We're trying to get it done. It's still basically next week. It's just next Friday now. Okay, so we'll see you back here then. Bond is continued.
Would you consider a modifying? That's a $5,000 10% bond with the certification on the website.
He's coming back next week. I'm not changing nothing. We'll get this done. Because if we have to change that, then that changes the whole sentencing thing, and they're gonna put it out even further. We gonna get it done. Okay, this is case number 25S Is Mr. Baldwin here? This is Mr. Baldwin. Oh, 25S00732SM. I think we're recalling people, State of Michigan versus Roderick Pope.
Robert Sharp on behalf of the people.
Good morning, Your Honor. For the record, appointing counsel Attorney Mike Baldwin, P 65417 on behalf of Mr. Pope. Clerk, can you just please state fully?
Roderick Lamont Pope.
Judge, thank you. Judge, last time we were here, we adjourned the discovery. I wanted to get the,
Video from a
Yeah,
third party hotel.
yes, Judge, and I did send a subpoena. I got no response. I wasn't anticipating getting one. In the meantime, I can follow up with them, but keep the matter moving on the docket. We have,
You also needed body cam. Get that? You also said you needed body cam. Did you get that?
I did make that. And I do believe that we tendered a proposed jury waiver form. We're going to ask to put this on a bench trial document.
Okay. Mr. Pope, you understand you have a constitutional right to a trial by jury? What that means is you, your lawyer, prosecutor would select 6 jurors from the community. They would listen to the evidence presented, and then they would decide what the real facts of the case are. And then they decide whether or not you've been proven guilty beyond a reasonable doubt by the prosecution, and they all have to agree on the verdict. So if you waive that right, you're asking the court to try the case, meaning that I sit as the trier of fact. I listen, I decide what really happened, what the true facts are. Then I decide if prosecution has proven you guilty beyond a reasonable doubt. And of course, my verdict is one person alone as the court rather than the 6 jurors who all have to agree. So understanding that difference, you still wish to waive your right to a jury? All right, anybody force or threaten you? Been promised anything? And you're waiving freely voluntarily. And this is after talking to your lawyer. And you also sign the form. And the prosecutor signed the form waiving his right. Now, that's a free and standing voluntary waiver, and we will set this for a bench trial. How many witnesses? And just so the record's clear, this is a domestic violence second offense.
It's 2, Judge, please.
2 for you, 3 for him? Okay, we might not get it in one sitting. That's 5 witnesses.
We can split it, Judge.
So we'll see what you can do for getting some of it in.
Court's available September 16th at 10 a.m.
I'm in front of Judge Matthews at 1. If we split it, I can do both.
Yeah, we're not gonna be able to
Okay,
go
then.
the whole day.
I'm sorry.
September 16th at 10 a.m.
Yes, 10 a.m.
All right, 10 o'clock on September 16th. We'll get this thing started. And then we'll pick another date when we have to recess it. So that'll begin the bench trial. His bond is going to be continued. And we'll give you copies of the waiver form.
Thank you, Judge.
All right, thank you. See you back here then.
These 2 are both Mrs. Matillo's, and she's on Zoom.
These who too?
These
You
2.
don't recall this one?
Don't call this one so she can go. She has to be in another court, she said.
What are these? Sentence.
One is a bond violation and one is a sentence.
You know, there was anybody else. Somebody named Madison there too.
Yeah, they should be rubber band together.
Okay, let's see. This is case number 25S00643SM. People State of Michigan versus Austin Petway.
Robert Sharp on behalf of the people.
Dion Patillo, P82378 on behalf of Mr. Petway. Mr. Petway, if you can hear me, can you state your full name for the court?
All right, Mr. Petway, we're here today for sentencing. Do you mind your counsel being on Zoom rather than in person? Because we would adjourn it if you had a problem with it. Okay. All right, so the sentencing should have this pre-sentence report here. Did you have a chance to go over it all with him, Ms. Patillo, and is it accurate?
Yes, Your Honor, I have reviewed the pre-sentence report. There are no additions, deletions, or corrections. I'd just like to address the recommendation.
Let me take a quick look at it. Mm. Okay, Ms. Patillo, I've read the report. What is it that you want to say?
So, Your Honor, I did that probation is recommending a 12-month probation. I would ask if the court would consider a shorter probation, just time enough for Mr. Petway to complete an anger management class. Also, he already made the payment of the $160. He's employed full-time at Playtech. He has 3 minor children who are 13, 12, and 6. I don't believe drugs and alcohol were an element of the offense. So I would ask if the court would consider also striking the drug and alcohol testing. And also, I would ask if the court would consider no assaultive contact with the complaining witness as opposed to no contact. Thank you.
Oh, okay, so this whole thing is about some money for a comedy show that you didn't end up going to. You broke up before the event occurred, so you wanted your money back. Is that what this was about? Okay, so then we get to all of this. You take the money off the dashboard of the car after you start arguing about it, and now you got to pay it back. What did you get out of this? What did you learn from any of this? There you go. Take the L and walk on away. You broke up for a reason. You got a good job. Yeah, $140. It's nothing to sneeze at. But you can make that up in a minute. Sometimes you just walk away and let it be. And now she's talking about you want more contact. Why? Why? You trying to go back? But it says she wants no assaultive contact. This your lawyer asking for that. That sounds like you want to have some contact with the lady. And I'm wondering why you want to have contact with her. You what? Okay. What do you want to say about the whole situation, if anything, and about yourself?
Sunday, was it? It's a loss.
Okay. Yeah, because and you got yourself worked up over that little money. and end up grabbing her. And there you go. That's just assault right there. And the battery. And of course you say she fell, but she fell. And then you put her back in the car and took the money. I don't know why you didn't think she was going to call the police and this was going to turn into something that it didn't have to be, but it turned into it. So now you just have to stop and think, because you're old enough to think. You know, you got kids, you're raising, young kids. And we tell our kids to stop and think sometimes. So we just got to do that now. Ain't nothing worth it. If you're going to fight like that, it ain't worth it. Just got to let them go. Take the L, as you say. Take the high road. Did she be the one wondering, well, how come she never heard from you again? What happened? Now she the one sitting there, yeah, he's this, he's that. As he hurt me and he took money and he did, now she can sit up there and talk like that. Whereas before, you'd have just let the breakup go. She'd have been wondering, well, you just let me walk away. We broke up, sure, but I never heard nothing else. She probably would have been calling you. So, but you do have to kind of think about before you act these days and say, is this worth it? Because you have a job to lose. If you go to jail, you got kids to think about. You want to be a role model for if you got young boys or young girls. It doesn't matter either way. You got to show them how to resolve conflict, what a relationship can be, should be, and if it's not, how to deal with it. This ain't the way. But it looked like you figured it out. Let's see, anything for the people? Okay. Yeah, is the 160 you pay, is that kicking the vehicle door? What was that for? Was that the money he took?
That was the money that was taken off of the dashboard.
Okay, so there's no damage to the vehicle that needs restitution.
She didn't answer that.
Okay.
Or advise me of any answer.
Okay. All right. So, sentence to the court. Did you wish to say anything else, sir? All right. I'm going to follow this recommendation. It's going to be for a period of 1 year probation, but you can be released after 6 months if you've completed everything. And ask for the form, fill the form out, say why you want to be released, the reasons why. Of course, probation will fill in and tell us what your level of compliance has been. Send it to the prosecutor. He has no objection. It'll come to me. Actually, I can't because it's a DV. Yeah, I was about to say I could because it's assaultive, but it's a DV. So we can't release you too much earlier than that. So what I'll do, I'll make it a little bit shorter period. Since we're not going through the full domestic violence HEAL program, I'm gonna make it 9 months of probation. And the oversight fees, that would be $360. Fines and costs here, $400. We'll give you 1 day in jail. Did you just get arrested or they give you a ticket? How'd that work? Okay, so you spent 1 day, 2, 3. Let's see what it says. It says you got 1 day credit. How many days? Okay, let's see. So you bonded out on August the 15th. Let's see. The event date was
6/19.
June 19th.
well, what is this bond for? Who knows what this is? Oh, that's the restitution. You probably got a personal. Let's see. It was 6/19. Is that what everybody said?
Yes,
Nope.
Judge.
And he was arraigned on the 20th, so that's the 19th, 20th, and they gave him a personal bond. So you get 2 days credit. So 2 days credit for 2. Give me 3 days community service at a nonprofit agency. No alcohol or unprescribed drugs. No contact with this complaining witness who is, let's see, Starlisha Brim, STARLISHABRIM. So I have no contact with her, meaning don't answer the phone if she calls you. Maintain your employment. And we'll do anger management classes. Also, let's see, there'll be a PSI screening fee of $100, $75 crime victims' rights fee. The restitution is $160 to just provide proof that it's been paid. Since you already paid it.
Yeah, the defendant showed me a receipt directly after the last court date of him paying it.
Okay, so you don't want me to order it then?
I've seen the proof, it's up to you.
Okay, well, I ordered it.
There we go.
So just show them the proof. Let's see. And I think that's gonna be it. Because we got the oversight fees. Yep. So that's gonna complete the sentence of the court. And there was this, there was 7694A spouse abuse as well, meaning that you won't have a record, sir, if you successfully complete this time. Okay.
Thank you, Judge.
All right, thank you.
And then I also have.
We got you. This is case number 19S01040 State of Michigan versus Javier Madison.
Deanne Patillo, P82378, on behalf of Mr. Madison, who, if he's not present on Zoom, he's not present.
He's supposedly a president, but
Yes, I'm here.
Okay, he's here. So, Judge, I appreciate you allowing me to appear by Zoom. Mr. Madison understands that he had to be there in person. Mr. Madison showed me a notice of hearing that he had from a friend of the court. And when you get those dates, you have to keep them. He probably wouldn't have been able to get another date until sometime next year. So I would ask either that we could do the hearing on Zoom, which I know court probably won't allow, but I would be asking for an adjournment so that we can have the bond violation hearing in person.
yeah, we got several different things to testify to, and you've got someone here from Abraham.
Correct. Second time she's appeared. Because around the first time the defendant showed up extremely late and she was dismissed as we issued a bench warrant. Not here again.
And so, Your Honor, at the last, that's somewhat correct, but at the last hearing, he was present, but he was on Zoom in another court hearing. He was there in the courthouse, though.
Yeah. All right. Well,
and if the court would allow, and I understand that AdverHealth has been there, I don't want to continue to inconvenience them. I have no issue with if the court allows. I don't have an issue with AdverHealth appearing on Zoom if the court allows.
yeah, the problem is you won't be able to really see her. I mean, and neither will the defendant, because, well, I got kind of a low camera that I can kind of focus over there, but you really won't be able to see her.
Okay.
And if you don't mind that, and I don't know what documents she has that, if any, that you might want to look at. So does she have documents?
Yes.
She has documents. So
Okay.
that's not gonna be practical. So I'm very sorry. I apologize. You know how it works around here. Sometimes we have hearings, sometimes we have these sticklers. So I'm asking now, and I understand the defendant was here before, and he has another court date. Does he have any more court dates coming up?
He just has some custody issues with his child, Your Honor. He has custody of his daughter, but he does have to attend these hearings.
Okay, but is there another one?
Mr. Madison, when is your next hearing?
The matter is set for trial, for the, I forgot what it's called, the juvenile hall today, but I'm not sure if the mother of my child is gonna do admissions or if she's gonna take it to trial. In the event that she does take it to trial, I might be subpoenaed, but I don't know those dates until later on today.
Oh, okay.
Okay. All right. So let's give another date here quickly. If we can do it fairly quickly. Like next week, maybe. And we'll check with the witness to see what her schedule is first. Too. What's it looking like?
Soonest judge will be the 16th.
The soonest. This is a bond hearing.
I mean.
It's a whole month away. I'm not doing that. Make it work. And remember, I said that. You can tell me I said it
Okay, so for the available,
when I start complaining.
September 3rd at 9:30.
Okay, September 3rd, 9:30. How is that for? Okay, 9/3 at 9:30. Ms. Patillo, you and your client be here.
I will, Judge. That works. Thank you so much.
Yes,
All right.
thank you so much, Your Honor.
All right, bond is currently continued. All right, we'll see everybody back here then.
Have a good day, guys.
Y'all have a good day.
And this signature. This was on this is 769-4A. Did you check the box?
I think I'm sorry.
See, you're gonna mess him up.
We did, this guy is out of in custody.
Where is he?
He's still.
You want to bring him on? Okay. Steele is gonna be next. I don't know what that is. This is case number 25S00528SM. People said Michigan versus Anthony Steele.
Robert Schrock on behalf of the people, Your Honor.
Mr. Steele, who lives the court train, please state your names.
Okay, Mr. Steele, we're here for pretrial, one count of assault and battery. Last time we were here on August 11th, it was just a stipulation in the file, so I don't know why we adjourned it. And then before that, it was an adjournment to track a related matter in the juvenile court, which the next date then was August the 7th. What's going on with that juvenile court thing?
That's been resolved short of a trial.
Okay.
And I have extended an offer to the defendant in this matter to plead guilty to one count of domestic violence, 3-day misdemeanor, 27694.
Okay. Is that what he wants to do?
Your Honor, I have had the opportunity to speak to Mr. Steele several times. I did explain the possibilities, obviously, that someone has when they're in. Explain the benefits of 769, for a plea, and it is my understanding that he would like to avail himself of that offer. He did. The prosecutor also indicated that he cannot be opposed to Mr. Steele pleading no contest. That's really
I'm not sure that.
All right, Mr. Steele, domestic violence is also a 93-day misdemeanor with a $500 fine. It allows this particular diversion under the statute 769-4A, meaning that we don't accept the plea today. We don't put it on your record. We sentence you to probation and we see how you do. If you successfully complete everything, then the case is just dismissed. There is no record of the plea. However, if you fail to do what you're supposed to do, you could be violated, and at that time, it could be put on your record. And obviously, you would subject yourself to additional jail time. So is that what you like to do? And your counsel indicates you're going to do no contest, meaning that I'm going to look at a police report to determine if there's enough information here to convict you. If I determine there is, I'm going to base it on the, what's in that police report, and you're not going to contest anything. And that would be a conviction, a potential conviction, but we would hold that without adding it as a conviction on the record at that time. Okay. All right. So
And I'm going to approach with Southfield Police Department criminal report number 250012633. And I'm going to ask sister counsel to stipulate for the same.
I will stipulate for the
okay, wonderful. And so what I'm going to do, sir, is use this report to establish what the facts are that occurred. And before I do that, I'm going to go over your constitutional rights. So if you understand your rights, all you need to do is say yes as I go over each right with you. If you have a question, of course, you can feel free to pose the question to me at the point in time I ask you if you have any questions. All right. So let's start with the fact that you do have a right to trial by judge or by jury with your counsel. You understand you're going to waive that right? At that trial, you also have the right to subpoena witnesses, which means to ask the court to order witnesses to appear to testify for you. You understand you're waiving that? You also have a right to question through your lawyer any witness brought against you by the prosecution. You understand you're waiving that. You have a right to testify on your own behalf, but if you choose not to, no one can hold that against you. You understand you're waiving that. Also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt by the prosecution. You understand you're waiving that. If you're on probation or parole and you plead no contest, this plea might be considered a violation of probation or parole status because it might be considered a new case. You understand that? You read and signed the full advice rights form. Have any questions about anything on the form or any of these rights I'm going over now? Understand if I do accept the plea today, you will not have a trial and you'll be giving up the rights listed there. You also understand the possible penalties involved for the charge of domestic violence. You still wish to plead to that charge, no contest. Anybody force or threaten you? You been promised anything? Are you pleading freely, voluntarily? And you understand if you wanted to appeal anything, you'd have to have a right to appeal or request permission to appeal, and you'd have to do it within 21 days of being sentenced and request a lawyer for an appeal if you wanted one within 14 days of sentencing. So you understand that? All right. So the report's already been read into the record. Date is April 16th, 2025. Address 21495 Independence Drive, City of Southfield. Okay. Well, the court, has looked at this, report. And I do believe there's sufficient factual basis for this no contest plea to, domestic assault. As the report does indicate that on the date and time indicated that officers, were dispatched over to the address on Independence Drive, the city of Southfield for a welfare check because a video of the defendant, Mr. Anthony Steele, had been going around school of the victim, who was his brother, with Mr. Anthony Steele disciplining him by beating him with a belt. And apparently, his brother is the alleged victim, Mr. Terrell Steele. And apparently, the parents or the mother knew about the discipline, was okay with it, basically, because she said Mr. Terrell, the victim, had been involved in an incident with a firearm, who apparently he had told his friend about a gun and where it was, and he was partially responsible for an armed robbery that had taken place because of him telling about the gun. And his mother's concern was that someone could have been killed or injured, and she thought it was appropriate for Terrell to be physically disciplined, which occurred the same night as the armed robbery after the officers had completed their investigation. And apparently, this video of this was taken by other siblings, and it somehow got around the school, and the school called authorities about this. And apparently, Mr. Anthony Steele apparently was interviewed at some point himself about the discipline, that this had been the second time that his brother had been involved in some type of activity regarding, a weapon, and he said it was his idea, not his mother's, that he needed to whip his brother. And so therefore he took a belt and hit him approximately 5 times across his arms because he kept raising his arms to defend against this. And that's where the contact was made. And that's consistent with the photographs that were taken of Terrell, which tended to show 2 marks across the top of his right forearm and 1 mark on the top of his left forearm. And his parents had indicated that he had numerous old marks from being a bad boy. Even though the defendant didn't live in the home, this is his brother. And he had lived there at some point. And it's common practice, she said, that he has taken over the discipline of Terrell. Terrell admitted that his brother disciplined him without the specific detail. This whipping did take place at home. He says he wasn't being hit hard. And he couldn't remember exactly what part of his body he was hit. But he did say he tried to block him. All right, so the belt, that's specific, I think, good enough factual basis. So you satisfied?
People are satisfied.
Satisfied.
Yes, Your Honor.
And the court satisfies well factual basis for the plea. The court rules have been complied with. And I find that this plea is freely, understandably, voluntarily, accurately, knowingly made. We'll hold acceptance into abeyance. And we will refer him for a PSI and domestic violence. So we need a sentence date.
Court's available September 29th at 9:30.
September 29th, 9:30, good for council.
That is good for me. So
Okay, so what we're gonna do, sir, we'll continue the bond. We'll send you downstairs today to probation. They'll interview just for some background. And you'll get a report. You'll get a chance to review the report with your counsel prior to the sentencing date. So try not to miss that interview date. Put it in your phone, because we won't proceed without that report. So you'll go down there, they'll give you a date to talk to them for the interview. And then you'll come back to me September 29th, 9:30.
thank you. Oh. Oh.
This is case number 25S00791FY, People State of Michigan versus Timothy Dansby.
Chuck, on behalf of the people.
Morning, Your Honor. Ben Donica, here on behalf of Mr. Williams.
Okay, Mr. Gotti, good morning. Sir, come on, can you get up? Can he move? No? Okay, sir, can you tell us your name? All right, so Mr. Dansby, today is the adjourn date for a probable cause conference on this charge of, this was a retail fraud, first degree. And so last time, Mr. Gotti, you needed some video discovery and you wanted to review all that. So did you get a chance to do that? Okay. Well, he didn't apparently, but did you look at it?
I did not receive it.
Okay, what happened with the video discovery?
I wasn't here in this case.
Huh?
I don't see it even in my file, so, what I can tell the court is, actually, this is back today, so I'll get it today instead of.
Oh, all right. Well, things might have slowed down since she was off. Okay, so you want an adjournment, Mr. Gotti, again, a brief one? I don't know. How long would you like?
Pardon me?
How long would you like it to be?
We have a trial next week starting in front of Judge Rowe, but it's only going to be a couple-day trial.
Okay.
So,
Okay, sir, put your hand down. Put your hand down. Okay. The following week.
Yes.
What do we have the following week? Not next week, but the following week.
Or just another
Another PCC.
for 8th at 9:10.
How about September 8th, 9:30? We'll get to you in just a second, sir.
The only problem I have is that my trial starts on the 4th. It should be done the 5th, but that's Judge Rowe's criminal call, so that'd be
So he won't be doing it during that.
trial.
Yeah.
That's right. That would be.
September 8th at 9:30 then. Now, what do you want to say, sir?
Say, Your Honor, that, first of all, this is supposed to be an examination, but I'm not asking for German. I'm asking for more. I also want to state this lawyer is being forced on me, because I can ask for one. I haven't signed for no attorney to be represented, so I don't know why he adjourned something where he's not even, I don't even have him to represent. I don't even.
How you gonna get the information?
I don't get the information, well, I said, apparently,
Sir,
bring to me and review it.
okay, the prosecutor ain't gonna bring nothing to the jail. To
Think
review.
about what the law says. I'm going by
Okay.
what he did.
I don't know what law you looking at. Okay, but the prosecutor's not gonna bring you.
I'm an inclusionary member of the bar by the Constitution of right. I have the right to be free and prosecute myself by the Constitution of the United States Constitution, which is the highest law of the land. Which determines the court limit. I also know that these individuals, I don't even know if these individuals are even practicing law. I don't even know if they like to practice law.
What they're doing don't matter. They're not on your case, sir. Sir, I'm not trying any facts. Okay? Number one.
Represented by legal lawyers, not person impersonating lawyers.
Okay, stop. You finished now?
No, I'm not, you told me stop, I'm not finished.
Okay, well, you're finished as far as I'm concerned. So this is what I got to say to you. First of all, we don't allow anyone to practice law that's unlicensed.
But
So-
that's not true.
Okay, let me just, I don't do it in this courtroom. Okay, sir, would you stop talking to Wolf? I have to have you taken out of here. Because you don't listen. You don't listen.
I have a constitutional right to represent.
Charles.
For.
Now, what I'm trying to tell you is this. The prosecutor can't bring you a video. And the video could be the crux of the case. We don't know what it shows. Your lawyer would be derelict and the person here, this, okay, well, this is the lawyer that's here that's been assigned. Okay, so he would be derelict in duty if he didn't get it, to look at it and to try to ask. Well, he doesn't have it yet, sir. And then he can ask, and
I'm asking for this due process.
okay, first of all, there's no basis,
In a timely manner.
the motion's denied. There's no basis to dismiss the case. Okay, not right now, there is not. And so he can ask to bring his computer into the facility to show you the video. If he gets it, which apparently the prosecutor didn't have it. This is the normal prosecutor.
I don't know.
Okay.
I'm like, let's try what for the court.
Okay, well, I'm just explaining to you.
Fine.
I don't know who lied or who didn't.
He got money, never got one because they never intended to go this far. They didn't think that I was gonna go this far. Thinking that I would come back to.
Okay. Well, guess what?
It's something I did not do.
Nobody asked you to take a plea. First of all,
I'll tell you what he asked.
he might have asked you if you wanted to. I don't know what he said. That's between you and him. But the bottom line is, he doesn't even have all the information to make a determination.
But they asked me when he
Okay, I don't know. I said I don't know what he asked you. That's between you and your lawyer. I don't get involved with that. So what I'm trying to tell you is nobody's trying to get you to plead, at least not here, because I'm not taking a plea on this particular case, even though I probably could take a felony plea. I'm not doing that. We're just here to see what's going to happen as far as the discovery and if we need to hold a preliminary exam or not.
not gonna, and it's not gonna be, it's not gonna be. Well, see, because this is supposed to be my examination. It's not-
This was not your exam. This was a probable cause conference date. All right, we haven't set the exam yet because we haven't gotten all the information to set it. So we're gonna go ahead and get the information and we'll make a determination if we're gonna set it just in the next week when we come back. So that's what we're gonna do. And you need to calm down, okay? Fine is continue.
I'm trying to be, right, I already know I get a little animal.
Yes,
That's when I know that I have been
but then the truth will come out.
about none of that because these people are trying to prosecute.
The truth will come out, sir.
And I'm not going for it.
Okay,
Going on with that.
all right.
Thank you.
Thank you. All right. Fine, let's continue.
Adios.
We'll see you back here on the 8th, 9:30. That's another PCC. All right, is anybody here on Benjamin Casacelli? Mr. McCarty? Don't see him.
This me this morning and informed me that he had food poisoning and said he'd be reaching out to the court.
Did
You
you,
want adjournment of, September 5th.
is the defendant here?
No.
Well, where's the defendant?
Probably tell the defendant not to.
Okay. So he's coming September 3rd on that? Okay. So, DeJuan Johnson, a motion hearing?
It's an adjournment as well. He didn't have notice.
No notice.
No, clerks didn't send a notice.
Okay. Marlon Mitchell,
I think he's on his way.
lawyer not here yet. What are we doing with Robert Champion?
Bring him out.
We're ready, I'm in.
Okay, let's go.
We have, um,
Let me call it. Hold on. And then I still got to go back. Did you get me what I need? Oh, she's coming. Ms. Desmova, I'll give you an opportunity. If you don't want to wait today, I can just give you a brief adjournment if you want to come back on the decision
So to the court, I could stay. I mean, how long?
after this exam, you know.
Exam, they are requesting adjournment.
They're requesting adjournment. Oh, okay. Well, let's do that then. It might still be today then. All right. Does he, I guess she told him to bring him out. All right, so, where's the file? All right, so this is going to be case number 25M00495FY. People State of Michigan versus Robert Champion.
Jason Senior, speaking, Your Honor, good morning.
Good morning, Mr. Sims.
good morning, Ellen Michaels, on behalf of Robert.
Ms. Michaels, good morning to you as well. We're waiting for the defendant to be brought out. Today is the date scheduled for a preliminary examination. There are several counts here, including count one being, let's see, one count of human trafficking. Let me just check the complaint because sometimes the docket's not right.
Joe got the complaint here. It's count one, human trafficking with minor.
Of a minor for commercial sexual activity. All right, might as well wait till he comes out. Sir, come on over here next to your lawyer. And tell us your name. And Mr. Champion, you come on over there next to your lawyer. All right, so we're here for preliminary examination, one count of human trafficking of a minor for commercial sexual activity. That's a 20-year felony with a $20,000 fine. And then we also have count two, prostitution, transporting a person, 20 years, $20,000 fine. Count three, prostitution, accepting earnings, 20-year max. And then count four is possession of child sexually abusive material. That's 4 years and $10,000 fine. And of course, these matters have the potential for registration as a sex offender as well. So you already know the charges, correct? All right. So today was the exam date, but we've just been told by Mr. DeSantis there may be a request for adjournment.
That's correct, Judge. The people are prepared to proceed. They are complaining witnesses here.
Okay.
My understanding is defense counsel is requesting it.
I'm requesting an adjournment for the following reasons. Despite sending a request for all discovery, I have not received all the discovery, including phone dumps, interview, video of the interview of the complainant, as well as some other things. I spoke to Mr. DeSantis about it earlier this morning. I had emailed him over the weekend. He had sent a video, an electronic discovery to me.
But it wasn't in there.
None of that was in there.
Okay.
Because I'm unknown to both he and I until this weekend, that none of that was in there. Moreover, I need to view the photographs that are the basis of the allegation of child sexually abusive material. I need to go to their office to view that. And finally, I received new information today regarding the origin of that alleged photograph that I need to investigate. I've also discussed that with Mr. DeSantis, and we'll have conversations with him prior to the exam date if we are able to come to a resolution on that.
So origin of the photo for the abusive activity?
For the CSAM.
Okay.
That's correct, Judge. My proofs of service do show that the videos of the complainant's interviews were sent, but Ms. Michaels is saying that they were not on the drive, so obviously, we're gonna check that out. But we were endeavoring to comply. Not sure exactly what happened. My proof
Okay.
said it's there, but really it's not.
All right. So how much time do you think you need, Ms. Michaels, to get all that, get it reviewed with your client and be prepared to know what you want to do?
I'm lost.
I need to see the picture. 2 weeks.
Okay. What do we have for 2-week adjournment? How many witnesses possibly if it goes? 2 to 3 witnesses?
Although, are you looking to do it on a Monday?
Not per se. Yes, no, just heard that.
Second piece and having on and off.
Court's available September 16th at 1:30.
September 16th is a
Not available on the exam all day.
Tuesday, and that's an off day. That we probably could have finished it. because that would have been a jury trial day. Oh, all right. Okay, try again.
Give me one moment. That 1 second. Court's available September 22nd, 10 a.m.
September 22nd, 10 a.m. That works for me.
Okay, the 22nd is a Monday. Let's make sure.
Be in the court, I do have another exam in Judge Nance, so I'll balance between.
Oh, not there. Which what time is that?
Says.
Just
I
not,
would try.
it's not gonna be your problem, so. Because you might not never get out of there.
Court is available September 24th at 10 a.m.
That works for me.
That's not. So,
Okay, the 24th at 10. Mm-hmm. And so that is going to be a Wednesday. And what else is on that docket? Well, can we cut it so we can get this?
Yes, Judge.
Just cut that docket off so we can have time to get this.
was that 10 a.m. Judge?
Yes.
Request that the debate be canceled so we can go back to NDOC between now and then day.
How big of a problem is that, Mr. DeSantis?
He's in Jackson. It's not that far.
I mean,
He's
I can't make any promises that he'll be transported properly, right? He's already here.
Just so you know, he's been in receiving since he's been here. He hasn't even.
Oh, we want to make sure he's more comfortable.
Yes.
Oh, what's he in Jackson for? He's already under
Rules
sentence.
violation for trafficking and pandering.
Oh, well,
He also was saying he's currently in a class there. That he can go fast if he continue.
well, I'm gonna leave this one up. I'm gonna leave it to the prosecutor because quite frankly, I'm not quite sure how easy and quick these writs can get executed. If this was a little bit longer, I would say for sure, but it's only 4 weeks. And by the time he goes, then he'll be trying to get him back because it takes you about 2 weeks for the writ, right?
It's supposed to, yes. We did get one in this time and less than that, but they were pretty happy about it, my understanding. It has been in the past. I was asked for a hold, Judge. The other advantage of the hold, I would say, is after Ms. Michaels comes to my office.
Because she's gonna have to talk to him. Yeah, no, we're not doing that because he needs to talk to his lawyer. And unless you want to drive up to Jackson with the information, which I don't think is a real good use of counsel's time when we got him right here. So you want to do a whole order? That's fine. I'll sign it.
I had asked for 2 weeks. Do you have a sooner date? I think not.
For a full exam? Probably not. Do you have anything sooner?
At the 16th.
But other than that, I mean, she's looking for something like, next week is September 1st, so.
This week.
You know, we get booked up on exams like real quick. Would you say by next week?
That's fine. Let's stick at the 24th. It's fine.
Did you have anything? Not really.
I would need to speak to Mr. Shockley. We might have him 12, but I need to speak to Mr. Shockley.
12 works for me.
Weeks.
Friday.
That would be fine.
The 12th instead of the 24th. Let's see. Yeah, let's see, Mr.
Sorry. So charging on this is a trial.
The witness is in trial.
My only third charge.
Okay. Well, I guess you're stuck, Ms. Michaels, with the 24th. We tried.
2 weeks.
Good. I have 2 minor things. One, I'm gonna submit a DNA or a fingerprint order because apparently there's a charge.
I'm surprised my clerks didn't see that. They would have sent an order up. Are you sure?
I am sure.
Oh, man. Okay.
The second thing is I was just gonna ask the court for a notice to provide to our officers here. Thank you.
Okay. So we're gonna need a whole order and a fingerprint order and they can get you the notice. All right. So his bond will be continued.
Thank you.
Okay, so that'll complete this unless there's something else that someone has to address. Okay.
Thank you.
Am I missing, Mr. Dick, are you here for something I missed? Marlon Mitchell? Okay. This case number 25M00483 SD, State of Michigan versus Marlon Mitchell.
On behalf of people.
Like on behalf of Mr. Mitchell.
Okay, Ms. Mitchell, state your name. All right, so we are back here on a pretrial for operating while intoxicated. We had adjourned it for a deviation request. Mr. Shockley, did we get one?
No, Your Honor.
No?
Your Honor, I don't know what happened. I have this scheduled for later this week. I was working on the deviation request today and got a call as I was headed.
You didn't finish it. He didn't deny it. You just didn't get it in. Oh, okay.
I don't know how I could have put this directly into my phone on the wrong date.
It happened.
I wish I had my phone in my hand when we're in this court. Try to get that correct, so I don't know what. So I apologize, Your Honor. Probably my fault.
All right.
I apologize. Yeah.
Let's get an adjourn date for a deviation request again. It should be our last one.
Yes.
Court available September 10th at 9:30.
How about September 10th? Anything good for you?
I have a jury trial. On that same date.
Okay.
Court's available September 12th at 9:30.
That's a Friday.
I'm available, Your Honor.
Okay, September 12th. How about you, sir? At 9:30. And that'll be for a pre-trial on this, and he'll get the deviation request in. And then, Mr. Shockley, is that enough time for you? September 12th, 9:30? Okay. All right, his bond is continued. Someone will give you notice to sign, and then you'll be all set. Okay. That one. And then that's pretty much completing the docket, but for the decision of the trial. And I'm just going to take a brief recess for that. Suggest?
Yes.
I'm going to take a recess and Charles isn't here, so you go ahead.
Oh, okay. All rise.